So the topic today is on accountability and justice post-genocide. I am pleased to be moderating this panel. I know both these gentlemen, Dr. Muleefu as an academic, and Serge as I am a former prosecutor of the ICTR, where I was for 9 years. So I'm very excited that we're having these conversations, and I want to take 30 minutes to have conversations with both of you, juxtaposing the domestic and the international aspects. And Serge has been, he works for the ICTY and ICTR tribunals, so he'll have a view on both sides. And Dr. Muleefu, being an academic, I think it's going to be interesting to hear these conversations. And then we'll open up the floor for questions. And I'll start with you, Dr. Muleefu. So many people don't understand the challenges that Rwanda faced in 1994, post-genocide. Can you paint a picture of the legal landscape of how Rwanda was in July 1994 and what the challenges were with regard to justice at the time?
Thank you very much. It's always difficult to describe how Rwanda was in '94, especially for people who have come to Rwanda for the first time. But I take the privilege of your presence and having visited some of you the memorial sites and the conversations that came before this one as an introduction to what I'm going to say. Just imagine a population at that time of Rwanda was estimated around to be 7 million people, a little more. About 1 million people had been killed. Close to 3 million people had fled the country, mainly to Zaire, as it was then, but also another large group of people had gone to the United Republic of Tanzania and other neighboring countries and beyond. Among them, including those who had participated in the genocide. You can imagine the justice sector was already weak before the genocide. Those who worked in the justice sector who had not been killed had participated in the genocide. Majority of them had also fled the country. To give you some figures, about 37% of judges were left in the country. 14 out of about 158 prosecutors were left in the country. 35 lawyers and 18 interns for the constituted the Rwanda Bar were only lawyers in the country. And out of 631 supporting staff in the judiciary, we only had 137 left. So that is on the personnel. But also, Rwanda did not have a law that punishes the crime of genocide. The Genocide Convention is not a self-executing treaty. There needs to be a national instrument that puts it into action. So there was no such an instrument in the country. The infrastructure was destroyed, and there were no financial resources because also the national treasury had been looted. So that is the picture of the justice sector. And it is on record that RPA leadership was encouraging its soldiers and survivors not to revenge on the promise that they were going to provide justice. So probably I leave it there.
So thank you. But in terms of the numbers of suspects, how many were in jails, and what were the choices faced by the government at the time in terms of delivering justice in those circumstances that you've described that seem to have been dire at the time?
because there was a promise of justice, this increased the massive arrest of suspects. And these individuals were being arrested by people who did not go to any law school to learn about criminal procedure. Some of the arrests were based on a single accusation, and we had around 120 to 150 between that range, thousands of people in prison conditions in a system that was supposed to be handling about 15,000 suspects. So you can imagine the conditions in which the suspects were in. So there was an outcry for justice, not only from the victim's side, but also from the perpetrators, and the pressure was increasing on the government because of the people that were in preventive detention under those bad conditions. But it was also equally difficult to suggest that you can release all these thousands of people back to their communities to live with survivors without any form of justice. So those are the challenges that the government was faced with to provide justice. It had requested for the establishment of the ICTR through the UN, and it had been established, even if Rwanda did not vote for it. And efforts were being, probably we'll come back to that, were being initiated in the country on how to handle the aspect of justice, but also reconciliation, because that was also another demand.
Thank you for bringing in the aspect of reconciliation. I would like to turn to Dr. Brammertz. The ICTR was established in those circumstances, but with some lofty ambitions of contributing to reconciliation in Rwanda. Looking back now, do you think the work of the ICTR has done that for this country or not? And even perhaps ICTY as well for the former Yugoslavia?
Thank you, Florida. Perhaps one word first before answering your question. I would really like to thank the organizers for having me. Those have been extremely interesting 3 days. You know, as a prosecutor, as an international prosecutor, we are coming in when it's too late, when the international community has failed a society. And it's a very frustrating exercise, as you can imagine. So watching what ages, what all of you, what all organizations represented here are doing on prevention, on education, is extremely impressive. So I really want to thank all of you for those very important efforts. Now the question is about reconciliation. And when the ad hoc tribunals were created by the Security Council for the former Yugoslavia and for Rwanda, it was about punishment, because I think we can all agree if prevention has not worked, well, punishment is there to create a kind of deterrence and to have a kind of prevention for the future. Unfortunately, when we look at the world today, this deterrence by international tribunals had not really worked as much as we would have wanted. Now, reconciliation, we are getting this question quite often, because every time a decision is coming out of one of the international tribunals, one community is happy, one is very unhappy, depending on the outcome. So sometimes we even get the criticism that our work is preventing reconciliation from taking place, because with every international decision coming out, you can see the voices coming up. Now, my answer is that, well, justice alone cannot achieve reconciliation. Reconciliation needs to come from within a society, by the communities affected, victims and perpetrators communities. That's why we also, as international prosecutors, are saying that the best place to have justice taking place is within the communities, in a language people understand, in a legal system they understand. So, but while I think that reconciliation as such cannot be achieved by accountability, I personally very much think that accountability is a precondition to give reconciliation a chance. Because if you cannot agree about the wrongdoing of the past, how can you as a community agree on how to move forward together? And of course, the Rwanda Tribunal, the USAF Tribunal only have played a small part. And if we see today the situation in the world, and Alice mentioned it already earlier today, and as she mentioned, we work very closely together because prevention and accountability, I think, go together. If we see the situation in Rwanda, I think we can very much agree that reconciliation at the different levels of society is a success story, where we see that in the former Yugoslavia, I'm much more pessimistic today than I was 10 years ago. Glorification of war criminals today is worse than ever. Political parties are very proud to take a convicted war criminal on their list. We even had one war criminal, alleged war criminal, acquitted in first instance, and his own community was saying, you see, he was not really defending our community, because if he had defended us correctly, he would have been convicted. Luckily, he was convicted in appeal, so we were, as prosecutors, still satisfied. But just to say that international justice needs to play together with the domestic system, which I think is a success story in Rwanda, because the Rwanda Tribunal has worked quite closely with the national jurisdictions. And I think the Gacaca courts played a very, very important role, but I guess we will speak about it.
Serge, for the first time, the ICTR indeed prosecuted the masterminds. They were arrested from all over the world where they were, because you had Chapter 7 powers from the Security Council. How do you think the fact that the masterminds were prosecuted, had their day in court, that is important for justice and accountability, and indeed contributing to reconciliation?
I think it was very, very important, as the professor mentioned earlier, and the situation was quite similar in the former Yugoslavia or in Rwanda. Once the judicial system domestically is destroyed, many judges, prosecutors were killed, infrastructure was destroyed, and in the former Yugoslavia, of course, in Bosnia and Herzegovina alone, you would have the 3 different communities, and who would be there to provide objective, independent justice? So I think that in a society which is very much destroyed at many different levels, international justice has and needs to play a role. And luckily in the 90s, where the Security Council was obviously working in a different way than it is today, and at that time there was a willingness to create international judicial mechanism, a willingness which is obviously not present today. So I think it was a wise decision to set up those tribunals, not only because the international community has failed to prevent those genocides to take place, but also because I don't think there would have been an alternative. And having people like Milosevic, Karadzic, Mladic taking out of the system and not allowing them to be the ones negotiating the peace agreements was an important decision, because this is one of those big problems, I think, in the majority of countries where conflicts are ongoing also today, that those sitting around the table to negotiate peace agreements are those who are committing the highest number of crimes, which is obviously an absurdity in terms of systems. And that's why we always thought that, historically, it has always been like this over the last hundreds of years, that those who committed the highest number of crimes would sit together about the negotiating table. The first thing that would be discussed and agreed upon would be amnesty for the crimes committed, and then only a country would move forward, and that's of course the origin of the next conflict. And that's why those international tribunals, why the ICC and others were created, just to have independent organs looking at it. But we know that this was very much wishful thinking when international tribunals were put in place. So just to say that I think it is important that those who bear the greatest responsibility for crimes committed are not part of the decision-making process in relation to accountability.
That brings me to a question that has been always a criticism of the ICTR and ICTY and their locations. Juxtaposing their location outside of where the crimes were committed, the criticism has always been that justice is not seen to be done, but at the same time I'm mindful that taking those people out of the situation and taking them far and giving them justice always gives a chance to countries to actually move on. What is your opinion on that? And I think a lot of people here don't know that the convicts from Sierra Leone are actually in jails here in Rwanda. And that is important because they are far from where they can influence the situation of what happened. What's your opinion on that, Serge?
In relation to where they are serving their sentence? Where the
tribunals.
Yeah. I mean, the location of the tribunals, I think, are always political decisions by the Security Council, right? When the wars in the former Yugoslavia took place, it was impossible to have those tribunals in the region, so it was decided to have them in The Hague. And for the Rwanda tribunal, I think a number of countries in the region were considered, but the then regime had some privileged contacts with some of the neighbor countries, and that's why it ended up being in Tanzania, which I think was a political decision in this regard. And the two court tribunals have agreements with more than 20 states in relation to the execution of sentences. And it was a guideline by the Secretary General in New York that convicted individuals would not be authorized to serve the sentence in the country of origin. So, for example, among the more than 90 people convicted in relation to the crimes in the former Yugoslavia, none of them is serving his sentence in the former Yugoslavia. They are a little bit everywhere. And of course, many of the persons convicted here are serving their sentence, all of them on the African continent, but all outside of Rwanda.
Dr. Muleefu, Serge has alluded to something, amnesty. I remember as a young intern at the ICTR, having a conversation with former prosecutor Carla Del Ponte and other interns. And one of the interns, I think she was from the US, if I recall correctly, she said Rwandans should just do truth and reconciliation and move on. So, Dr. Muleefu, why is it that Rwanda chose to go the route of gacaca, not truth and reconciliation and regular court systems? What were the choices at the time? And you having taken part in gacaca, what do you think its contribution has been to accountability in this country?
I think I will need to spend a little bit more on the background before I get to that. So the situation I described is of about the first 2 years, immediately after the genocide. Then Rwanda, in contemplating on how to provide justice and reconciliation, it was from 31st October to 3rd November 1995 that an international conference was organized on how to achieve all those objectives. And in that conference, there were 4 recommendations that were made. One was to establish specialized chambers in ordinary courts, categorization of suspects based on the seriousness of their involvement in the genocide, to introduce greater pleas, to increase the speedy trials, and exclusion of death penalty, because Rwanda had death penalty at the time. And from other categories except to the first category of planners, organizers, and the masterminds of the genocide. So in 1996, there was an introduction of the specialized chambers. So 12 specialized chambers were established in ordinary courts and 4 appeals chambers that were to deal with the genocide cases. But it did not take long to realize that this was not going to deliver justice as it was intended. If it was estimated that if we went to the pace of Rwanda's ordinary courts, it would have taken Rwanda about 200 years to complete the trials of about 130 suspects, but also others who were still at large. If we went by ICTR standard, we would have taken over 10,000 years. And certainly that is justice that we were not going to see, be the victims or the suspects. So that's how, then I come to the question you raised. So that means that Rwanda was left with at least 3 options to provide amnesty, blanket amnesty, and go for Truth and Reconciliation Commission as South Africa approached it, or to do selective prosecution, only focus on those who bear the greatest responsibility, or to go for prosecution of all suspects. Given the background that I gave, and given the history of impunity that had happened, so I think, again, people need to know the background of the genocide against the Tutsi. You start with the registration of impunity starting from 1961. And the first decision was by the UN General Assembly, and the resolution 1605 Roman 15. In its paragraph 9, it recommended to the Belgian government at the time, in the situation of, it was looking at the future of Rwanda, Burundi, and it recommended, because this was responding to the killing of Tutsis in 1959, that they should provide full and unconditional amnesty to the perpetrators. Then that was followed by the registration of amnesty laws in Rwanda immediately after Rwanda got independence. There are 3 on record. Every after the killing of Tutsi, there was a passing of an amnesty law. Up until 1992, after the killings of Tutsi in Bigogwe and Nyamata, in Bugesera, Nyamata included, that an amnesty law was passed. And in the process of encouraging perpetrators, the massive involvement of Hutu peasants into the killing of their neighbors, there was this understanding that they were not going to be held accountable. So for Rwanda not to go for prosecution would have been like going into the same narrative of the preparation of the genocide. So Rwanda, in the discussion, they were convinced that that was not a right decision to take. But going through ordinary courts had also failed, as I've described. So the discussions that were taking place in Village Rugwiro in the president's office concluded that they were going to go for Gacaca courts. And this is a traditionally inspired mechanism, community-based, that would provide justice. And the conversations I have had with people who were participating in those discussions, they clearly understood that Gacaca courts that was going to be practiced was neither Gacaca nor courts, because the name, if you can use the official appellation of it, is Inyiko Gacaca. And there was a hyphen. That hyphen is very important, because it was to find something that is between courts and the traditional Gacaca, to be able to provide justice that is both reconciliatory, but also that holds those that are responsible accountable. So in that agreement, that's how we saw that the genocide responsibility was individualized. It moved from the community collective responsibility of saying Hutu perpetrators of the genocide against the Tutsi, but communities now understood who is responsible within their community. Something very important that one of the important phases of Gacaca courts was the collection of information, and I'll probably stop here and we can come back to that if time allows. Every individual who was in Rwanda during the period of the genocide was asked to fill a form that provided what you can call forensic truth about who are the people who were killed in the genocide within their area, who were from within their community or outside their community, what were the roadblocks within their community, who were on those roadblocks, and then after collecting that information, there was a phase of validation. So communities came together to validate information that was collected within their smallest communities. And based on that information, that's how the list of suspects was drawn, and the suspects were categorized based on their level of participation. And that created something very important, because communities had a narrative of what happened within their communities, and that helped them to move forward. When Gacaca were closing 10 years after, close to 2 million cases had been handled. There were about 10,000 cases handled through ordinary courts, and ICTR had tried less than 100 cases. So I can say that you cannot argue that Rwanda is not a forgiving society, because Gacaca integrated aspects of asking for forgiveness, pardon, community sentencing, and suspension of the sentence for those who requested for pardon. It is only those who did not want to participate in the confession process that the moment they were found guilty, that their sentence was to be spent in prison.
So I'm told we have a challenge of time, but as we are almost wrapping up, Dr. Muleefu, what's the status of accountability for the genocide against the Tutsi at the moment, in your opinion, especially with the fact that Rwanda is still looking for fugitives all over the world?
Of course, after the genocide, as I said in the beginning, many people fled, especially those who were in leadership position, fled the country to so many different countries, even far as in Europe, in North America, and other places. But the majority are also within African countries. So, since the establishment of the Genocide Tracking Unit, the National Public Prosecution Authority has issued over 1,000 international arrest warrants for people living in different countries. And we've had some cases of extraditions and deportations and transfer of cases from ICTR, which is recommendable. But there is a lot to be done, because these people are, with their supporters, are the ones that are behind the genocide denial and all sorts of negative publicity when it comes to Rwanda. We can ask ourselves, I think the fundamental question is, are other countries have a responsibility over crimes committed in other countries? Even if the responsibility to prosecute, extradite is not yet a customary international rule, if you look at the Genocide Convention, the Convention Against Torture, and the Geneva Conventions generally, they all talk about the responsibility of states to prosecute or extradite. But the most important hindrance, I think, has been political will. Some countries are not willing to cooperate. Of course, there are some practical challenges, identity of suspects, the way they move from one country to another, and the ability to use their resources to hide in different places. We recently had, I think, Prosecutor may talk about the case of Kabuga, who was arrested just at the doorsteps of the tribunal, but who had been there not for so many years. So the ability of suspects to hide also makes it a challenge, but also the willingness of states to cooperate with Rwanda to deal with these cases is also a challenge.
Serge, I have two final questions for you. The first one is on the point that Dr. Muleefu has ended on. The fact that there are so many fugitives still out there, and your role as the prosecutor and how you're working with Rwanda to find these fugitives, and what more you're doing together to make sure that justice continues to be done. That's the first question, and then after that I'll ask you.
Sure. You know, for many of our interlocutors, when we have visitors from the diplomatic community, politicians, for many outside Rwanda and the former Yugoslavia, what happened 30 years ago is more a kind of historical event, not considered anymore the #1 priority, which partially one can understand if we look at the world today and all the ongoing conflicts. But everyone who met with a survivor in whichever conflict knows that for the survivor who lost so many loved ones and so many members of their families, every morning they get up, they think about their loved ones, and every evening they go to bed, it is in their minds. And so it remains extremely important, even 30 years later, to look at accountability and prosecutions and to make sure that no one is getting away with it. Now, at the ad hoc tribunals from Yugoslavia and Rwanda, we were fortunate enough to be able to close all our remaining fugitives cases. The last one, we arrested Kaishima in South Africa last year, after having been a fugitive for so many years. We're still waiting for South Africa to send him to Kigali after more than 1 year of detention. And when he was arrested in May last year, the following days, I went together with the Prosecutor General of Rwanda. We went to Nyanje, the church where he allegedly killed, together with the priest and the mayor. He was the chief of police, more than 2,000 women and children, by having a church put on fire and having this building collapsing with all the victims inside. So we went to see the survivor and the victims, and we could also see again how important it is for survivors to see that those who are responsible for their suffering are prosecuted. And indeed, as we have now arrested all our fugitives, we are working very closely with the Prosecutor General in Kigali. We located already a few additional fugitives he's looking for. His list, his priority list is 1,146 fugitives, several hundred of them being in the DRC, which explains, of course, a lot as well, but also several hundreds in Europe and other countries. And we are working together, and I'm approaching those governments once we locate those fugitives to say to governments also within Europe, there are two options. Or you extradite, and if for whatever reason you can't, for legal reasons or political reasons or judicial reasons, well, you have to prosecute yourself. And we have, in relation to the genocide against the Tutsi in Rwanda, more than 1 million pages of documents. So we're supporting dozens of investigations around the world in relation to the crimes committed. It's an important work we are still doing, and we very much hope that we will have the means to do so. It was my message to the Security Council. So like Alice, we also report every 6 months to the Security Council about the progress or absence of progress in our work. And my message in June to Security Council was very, very clearly to say that, well, I think the United Nations has relatively positively fulfilled the mandate of the 2 ad hoc tribunals. But this is only one part of the story. If as international community, we are not supporting national jurisdictions to do their part of the work, I think we have failed as international community. That's why we really think that domestic prosecutions need to be supported wherever they can take place.
I think my last question you have partially answered, but I would like to ask you, for communities that are facing mass atrocities, who are thinking about how to go about accountability, what do you think the best way of doing accountability is? Ad hoc tribunals, ICC, hybrid tribunals, domestic trials? What do you think is the best option?
Well, there's no one-fit-all solution, definitely not when we speak about accountability. you know, when we have new lawyers coming into our UN offices, and we have currently something like 60, 70 nationalities, brilliant students from the US, from Europe, from African countries, from Asia. And I'm always, in my introduction talk, saying, look, you are a brilliant student, fantastic, happy for you, but I need 50% space in your brain from now on, because you have to learn that when you are confronted with a problem, you have to learn that perhaps you know the solution, probably not, and you have to learn. And that's why I would never suggest, well, the only solution is ICC or hybrid or local. I think it's always about an integrated solution. The best option is, of course, always to have justice delivered where the crimes have been committed. We know very often it is not possible. The international community should come in. And I think the way, definitely among the more positive stories, I think the Rwanda story is one of the most positive ones, where you had really an excellent interaction between the United Nations with the Rwanda Tribunal, national legislation, which really put a lot of emphasis also on guilty plea, on having, even at the national level, people coming forward to plead guilty, also to avoid too many cases. And then more than 1 million gacaca trials. You will have people who will be very critical about it, will say, well, what about the rights of defense, procedures, etc. But I agree with my colleague that because of the numbers of perpetrators, because of the number of cases, it would have been impossible to have international or classic national justice addressing all the crimes. So that's why I think every single crisis in the world needs a tailor-made solution where you have to contextualize historically and for many other aspects.
Thank you so much. Can we thank the panelists for their presentations? And I sincerely apologize, but I've been told that there's no time for Q&A, but the panelists are going to be available, I think.
No, we have 10 minutes for Q&A.
Okay.
So we'll have volunteers hand out mics, but I would just like to remind everyone to keep your questions short and to also let the volunteer hold the mic. Thank you very much. Where's the try? Okay. So we have
Thank you very much. I am Farina from Documentation Center of Cambodia, and we have 2 colleagues here as well. So I have 2 short observations and 1 question to our speaker. So one, because very interesting conversation from Cambodia, who also had the extraordinary chambers in the Court of Cambodia and considered as a hybrid tribunal, which took Cambodia over 27 years to have these seen the crimes committed in 1975 until 1979. So one thing, I'm glad that you also mentioned about the location, where the location matter, where the court held. So for Cambodia, of course, it matters. And it could have been different if it was held somewhere else. Because we talk about reconciliation, healing, so it's also a way for people to participate in the court. And hundreds of thousands of people and survivors were able to participate, to express, like even very emotion, but then, still. And the other thing about the, so you also talk about the, like now we listen to you as a prosecutor and the one who advocate for survivors or victims. But it could have been different if we listen to defense lawyer, because for us we work with different units, like defense lawyer, prosecutors, office of prosecutor, and judges. And we just had a conference in May in collaboration with the Office of the Prime Minister and the Council of Ministers in Cambodia. And we also invited the defense lawyer. And he had also many other comments, a lot of things about the court. And so sometimes it is depressing and heartbreaking to listen to defense lawyer. But of course, it's something that we also need to hear from all sides. And my question would be about the archives, because we also have discussed a lot in Cambodia about the ECC archives recently, and now, like they're gonna have the institute to kind of preserve the archive and disseminate the archive. But what about Rwanda? Because the court was held outside of the country, and then in terms of the archive, how much or to what extent that Rwandan people can access to the archive, especially the court archives. Thank you.
Good afternoon. First of all, thank you so much for your speeches, so sincere and so full. So, being a war crimes lawyer from Ukraine, I work on the daily basis with also the Genocide Convention, with the Office of the Prosecutor General, and with the investigative authorities. And what we're seeing that the Genocide Convention, unfortunately, it's more political declaration than a real legal document. So I would have probably two questions, Serge, to you. First question would be, does the Genocide Convention really need some amendments or changes? And the second question that comes to prevention, we still have an international crime claimed by the convention as an attempt to commit genocide. But what we understand, in Ukraine, that it's almost not possible to claim this crime because still you need to prove it and it's quite tangled and etc. So how realistic it would be to claim the attempt to commit genocide, considering that this is the main goal of the convention? Thank you.
I think we have time for one more question, and then we'll ask you to give your answers.
Alphonse, my question is for you. In setting up the Gacaca courts, at a time when levels of trust in the country were so low, what was the process by which you found the people and the professionals that the community would trust to handle that system?
I think we begin with Serge with the two questions. But in answering the question on archives, I think it would be really interesting for you to elaborate to the participants what's actually contained in the archives. Because there's been a criticism about how few cases that the ICTR did. But what is contained in that archive actually explains why there was so much work for so few cases, in my opinion.
Yeah, in relation to our colleagues from Cambodia, and I think the location of your tribunal, hybrid tribunal, being in the country has been of paramount importance. One of the big problems the ICTR and ICTY had, because it was in a different country, that there were not many survivors, victims, who will really be able to participate in proceedings. It was more on an exceptional basis. And I know from my colleagues, prosecutors of the Cambodia Tribunal, there were thousands and thousands of people who came to the courtroom to see the most powerful man in their country deciding like this about life or death, facing the judges in a courtroom. So I couldn't agree more. In relation to archives, we have the archives in the Netherlands, and we have, of course, the archives in Arusha. In the Netherlands, I remember having a meeting with 3 members of the presidency in Bosnia-Herzegovina, where one said, well, we want this country, those archives in our country, and the other member of the president said, you put your archives wherever you want, except in my country. So it is a very, very political debate, and for example, for the archives of the Yugoslav Tribunal, I think it's my very personal opinion, it's very likely that it will stay in the Netherlands because it concerns so many different countries. But having said that, it's really a political decision by the Security Council, so I'm just expressing my personal opinion. For the Rwanda Tribunal, already for many years, Rwanda is asking to have the archives moved to Kigali. I think it's a very understandable and legitimate request. It was repeated as a request again by the permanent representative of Rwanda in the in New York. He mentioned it in the Security Council last year. In the past, I don't think it was really on the agenda because trials were ongoing and the archives were absolutely needed for the ongoing trials. But I understand that it is an open question today in terms of access, in terms of location. But again, it will be a political decision by the Security Council, who has put in place the 2 tribunals and is in charge of the archives. It's difficult for me, if not to say impossible, to make comments on the Ukraine situation. So please understand that's not possible because, we have as a kind of rule within the UN system that we only comment in relation to areas which are part of our jurisdiction. So I will just give a more general answer. For the former Yugoslavia, we only have one genocide conviction, which is in relation to Srebrenica, where within a few weeks, all men of all ages were executed. And this was considered as qualifying all the genocide criteria. As prosecutors, we had also argued that what happened during the siege of Sarajevo, where many thousands of people were killed, where more than 1,000 children were killed by snipers. It's still one of the cases we are looking at. Where in the municipalities, in more than 50 municipalities, tens and tens of thousands of people had been killed, but where also a majority, in fact, got the opportunity to leave or could flee. And where our judges were of the opinion that here the criteria in relation to the commission of genocide were not fulfilled. So it's very much a question of interpretation by judges. It's a question very much about intent. You have to establish as a prosecutor in the courtroom, so it's quite complex. But I want to say is that I know we always speak about genocide as being the crime of the crimes, but it is as important as crimes against humanity and war crimes. If you are the individual victim, if your family is killed, if as a woman you are raped, and the qualification is it is a war crime or it's a crimes against humanity or a genocidal campaign, I don't think we should use it as a criteria to measure the gravity of the crime committed, because for the individual, all those are mass atrocities, and I think we should always put much more the emphasis on the protection of the survivors and the witnesses, about accountability, about getting the perpetrators convicted, to look much more into this question than into the very heavy question of where is genocide starting and where it is ending. Thank you.
Dr. Muleefu, final question? Sorry,
I cannot resist to talk about archives. Because I remember a journey. I started in civil society. And I remember, I think it was around 2006 or 7 or 8, I can't remember exactly. There was a discussion at the ICTR about the legacy of ICTR. And I took a bus through Kampala to Nairobi and ended up in Arusha, and we were in the conversation. And the Rwandan team were saying these archives should come to Rwanda. The Netherlands was arguing that The Hague is the world capital of justice. They should go to The Hague. And Tanzania was arguing that we hosted the tribunal, we should also host the archives. And then I will never forget this, a UN official who I will not name, who was chairing the discussion, said, but these archives are of the international community. And from my frustration, I stood up and I said, but Rwanda is also part of the international community. So what do you mean? They can be in Rwanda and still be part of the international community. So at the end, I stopped following up on the discussion because there was a lot. I think that is one of the political decisions that needs to be made. And sometimes beyond what we can discuss here and recommend. That's a very good question on gacaca courts. And I think lawyers need to be humble sometimes and accept the fact that law rights are not the only important values. Integrity is an important value, honesty, social cohesion, unity. There are so many other important values that help societies thrive. So for Rwanda to be able to manage the process of gacaca courts, they focused on people with integrity within communities. So primarily, those who had not participated in the genocide could only be among the people to be elected as judges. Unfortunately, we had some cases where we ended up with the judges who had participated in the genocide in some instances. I remember, so another part of me is that I was a legal officer in the Gacaca courts. So there was a judge in the courts that I was supervising who had, during the genocide, was living in Kigali and had participated in the genocide in Kigali. But in his community, they had no information about his involvement, and he was elected as any other person to be part of the bench. So one time I was with him, with other judges, discussing, and then when I got back to Kigali, I found my colleague who was supervising Gasabo because the Gacaca courts could try in absentia. People could not be identified where they were, jugement par défaut. And then she had an arrest warrant that she wanted me to transport to Rulindo, where this judge was serving as a judge. So the question we asked ourselves was, did the judgments in which this person participated valid or not? But because Gacaca courts worked as a bench, so there were sometimes 7 judges or 5 judges on the bench, we say the decision was corrective. So we cannot say that all the decisions that this individual participated in were not properly adjudicated. We had the cases of people who were very influential, who could bribe witnesses or judges, and in those kind of circumstances, we would use a Gacaca court from a different area, and then be brought to this other place to be able to neutralize those kind of tensions. And so Gacaca court, as I said, it was something between normal courts and the traditional Gacaca. We practiced hyphen. We did not practice Gacaca or normal courts, something in between, to be able to see that we can achieve a sort of fairness that would allow people to move forward. Otherwise, there is no justice that is possible to address the magnitude of crimes about the genocide and mass atrocities. Thank you.
Serge, would you like to say a final word on accountability and how we all move forward from mass atrocities?
Well, I could start a new speech now for the next 2 hours, right? No, look, you know, the kind of work all of us we are doing, the thing is that I don't think we need to convince anyone in this entire audience about the importance of prevention, of prosecutions, and what we do together. So I consider this as a kind of big therapy group meeting where we are all, because I think it was mentioned by a number of our friends here that they feel sometimes a bit lonely in what they are doing. That's definitely for Alice. You know, she's a special advisor of the Secretary General, and everyone is expecting that she's coming up with solutions, right? Very often it's the same for prosecutors. So, and we are very much used to face criticism, but we always take the criticism as an encouragement to do better and to work hard. Definitely in the UN, where I think many of us, all of us are very, very committed. So just to say that I'm really, really very pleased to have been part of this exercise, and I know it is, the message is, the world is not going well, but all together we can perhaps make a difference, and that's, I think, the objective of this conference. Thank you.